Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we will discuss different topics of consideration for stakeholders in the clinical research industry in a post-Dobbs landscape. I'm your host, Megan Robertson, and I am an attorney in Epstein Becker Green's Washington, D.C. office in the healthcare and life science practice. When the Dobbs versus Jackson Women's Health Organization decision was released back in June, which effectively removed the federal constitutional protections over abortion, it triggered a series of changes for healthcare providers and patients alike across the nation with respect to abortion services. The immediate question, of course, was whether and to what extent abortion was permitted by each state. EBG has been following these developments closely through our From Roe to Dobbs working group and our own 50-state survey, which listeners can learn more about on our firm website. In addition to impacting the ability of people who are pregnant to get an abortion and the extent to which providers are able to offer abortion-related services, the Dobbs decision also has implications for certain aspects of clinical trials and research, which we will be discussing today. We're going to talk about how the changing state laws and regulations post-Dobbs may impact clinical research in different ways for different stakeholders. As always, if you like what you hear during our episode, please subscribe to Diagnosing Healthcare, which is available wherever you get your podcasts. Joining our discussion today is Kate Heffernan. Kate is a member of the firm in our Boston office and has a practice focused on the clinical research industry. She regularly counsels academic medical centers, hospitals, universities, research institutes, startup biotech companies, and other research stakeholders on a comprehensive range of issues in connection with research and medical innovation. So welcome, Kate. Thanks for joining us today.
Thanks for having me, Megan.
Of course. We also have Marylana Helou, who is an attorney in our Boston office and similarly focuses her practice on advising clients in the biomedical research space on a wide range of issues related to human subjects research and data privacy, including, for example, compliance with the applicable regulatory requirements, structure of research agreements, and conflict of interest issues. Welcome, Marylana.
Good to be here.
Great. Before we dive in, I thought it might be helpful for the listeners to lay out the regulatory landscape of clinical trials and human subjects research. Marylana, can you give our listeners an overview?
Sure, I'm happy to do that. At the federal level, we have the Federal Policy for the Protection of Human Subjects, which was published in 1991. The policy generally applies to human subjects research that is conducted or supported by one of the federal departments and agencies that have codified the policy. So, for example, the Department of Health and Human Services, HHS, has codified the policy at 45 CFR Part 46, and it includes 4 subparts. Subpart A, which is also known as the Common Rule. Subpart B, additional protections for pregnant women, human fetuses, and neonates. Subpart C, additional protections for prisoners, and Subpart D, additional protections for children. The Common Rule generally requires that researchers get informed consent from those who participate in research, and this includes giving them information that they would need in order to make an informed decision about whether they want to participate or not in the research. And of course, this would have to be done in language that the potential participant could understand. Another key protection is the requirement for appropriate review and approval of the research by institutional review boards, otherwise known as IRBs. They are committees that make sure researchers follow the rules and ethical guidelines as they carry out their studies. And it's important to note that the Common Rule was revised in 2018 to reflect how research has changed since 1991, which is a lot. And I should also add that many institutions can elect to and do elect to apply the Common Rule to all of their non-exempt human subjects research, regardless of the source of funding or support. And to the extent the clinical investigation involves an article that is regulated by the FDA, so such as a drug or a biological product or a medical device, the FDA oversees those clinical trials to ensure that they are designed, conducted, and analyzed and reported according to federal law and good clinical practice regulations. The FDA maintains a separate set of regulations for the protection of human subjects that is codified at 21 CFR Parts 50 and 56. And the FDA's rules are very similar to the common rule, but they're not identical. In the fall of last year, the FDA issued 2 notice of proposed rulemaking to harmonize the FDA's human subjects research regulations and the overview of cooperative research by a single IRB with those of the common rule. Many clinical trials also take place at hospitals or academic medical centers, which are covered entities under HIPAA, the Health Insurance Portability and Accountability Act, and so they must comply with its requirements. The HIPAA privacy rule specifically establishes the conditions under which protected health information, or PHI, may be used or disclosed by covered entities for research purposes. So that, of course, can come into play as well. And although when we talk about clinical research, the focus can be on these various federal legal frameworks, stakeholders should certainly be mindful of state laws and their impact on clinical trials. Certain state laws may directly regulate the conduct of human subjects research. Others define who is legally capable of providing consent and can provide additional protections for clinical trial participants or special populations. Some states have laws that impose confidentiality and specific consent requirements for the disclosure of certain sensitive categories of information, such as genetic, mental health, substance abuse, HIV, and of course, relevant to our discussion today, reproductive health information. In most instances, these laws often provide greater privacy protection than HIPAA, and so they are not preempted by HIPAA. In short, the state laws can definitely have an important impact on clinical research, and the failure to comply with these state laws and regulations can expose sponsors, investigators, IRBs, or institutions to significant liability risks. Those are the key frameworks. Of course, there may be others that are applicable to studies and can come into play depending on the type of research and the details of the protocol.
Great. Thanks, Marylana. I think it's safe to say that the regulatory and legal landscape that oversees clinical trials and research in the U.S. is a lot more complex than most people might realize when they, don't work with it on a regular basis like we all do. And with that context, with that background, how has the Dobbs decision impacted clinical trials and research? Are there certain types of trials that now pose new challenges or maybe new considerations that stakeholders should be aware of?
Well, Megan, most obviously, I think we can say that any trials that are actually studying abortion drugs, abortion services, different types of procedures aimed at, providing abortion care are going to be clearly directly impacted because they are subject to the same state requirements as providing those services in a clinical setting. So if something is going to be impacted on a clinical level in terms of a state law prohibiting or limiting its availability, that's going to extend as well to the clinical trial context. It's important to note that a lot of these procedures and abortion care related research protocols have always been subject to some type of state regulation, depending on the state. There's many, many states who pre-Dobbs have had various levels of legal restrictions or protections related to how research is done on both pregnant women and on fetuses and embryos. So this isn't a new issue per se, but given the degree of state restriction that has ensued post-Dobbs, we're now seeing an entirely new level of state regulation that's going to have to be considered in connection with research trials that are addressing abortion care. I think in addition to those more obvious implications, there are also other types of research studies where the impact may be less obvious. For example, many investigational drug trials have potential implications for participants of childbearing age that the sponsors, sites, and ethics boards need to take into consideration. If a study drug has the potential to cause harm to a developing fetus, which is often a possibility given how little is known at the time of a clinical trial, then the research protocol will require that participants, and in some cases their partners, use an acceptable form of birth control to avoid pregnancy. And participants who can bear children must have a negative pregnancy test prior to receiving the study drug. If a participant or a participant's partner becomes pregnant in the course of a trial, that's a reportable event, and the risk of that occurring is something that participants must be willing to undertake to be part of the trial. Now, if you overlay new state legal restrictions regarding abortion care post-Dobbs, sponsors and sites need to consider the potential implications of an unintended pregnancy occurring in the course of a drug trial. If sponsors and sites want to assist participants with access to abortion care in light of the risk to the pregnancy from the investigational drug, what is the potential legal liability for them in doing so? Is the legal risk of pregnancy and the potential recommendation to terminate a pregnancy due to the exposure to the investigational drug something that needs to be highlighted in informed consent forms and considered by IRBs when deciding whether a trial should proceed? Overall, we see research sponsors moving away from citing drug trials in states with these restrictive laws. And what does that mean for patient access to potentially helpful investigational drug trials in those jurisdictions? These are all questions that I think are still playing out.
For sure. Thanks, Kate. And I think one thing that's been a hot topic lately is pregnancy test and period tracking apps and the development of those types of products, and which requires clinical research. So what are some of the considerations that sponsors and sites need to be thinking about with respect to that type of research involving pregnancy tests and period tracking apps?
So building on what Kate said, pregnancy tests are frequently used in certain clinical trials. They are used generally as a screening tool prior to enrollment to exclude potential participants with positive results from participating in a study, or they can also be used at various study intervals in order to protect these individuals and their developing fetus from any potential harm in the case where the article being studied might have an adverse effect on the fetus. And clinical trial protocols usually also include detailed procedures that should be followed if a participant inadvertently becomes pregnant during the study. That said, more recently, the research community has recognized that pregnant individuals should be protected by research, not from it. And excluding these individuals from research when it is not warranted has resulted in physicians needing to make medical decisions for pregnant individuals that are really not based on research or evidence. I mentioned early on that the common rule was revised in 2018, and one of the changes made included removing the term pregnant woman from the list of vulnerable categories of subjects, which is another indication that we're seeing a shift in how stakeholders view the relationship between pregnant individuals and research. And this is all to say that, as you can imagine, in connection with these types of studies and for studies that, for example, like Megan, you mentioned, that use apps to track a participant's menstrual cycle, sites and sponsors have access to oftentimes identifiable health records and fertility data that shed light on an individual's pregnancy status, abortion, and law enforcement could seek such information either directly from the entity collecting the data or from another entity the data has been shared with. So, some of the things that clinical research sites and research institutions may want to think about include, first and foremost, do the changes in state law post-Dobbs impact their ability to continue any existing research studies and any existing agreements related to research? Do they need amending, including, for example, clinical trial agreements or material transfer agreements? Do they need to record why someone was excluded from participating in a study, and how will they manage that? How will they be required? Will they be required to share pregnancy data with the state? And I think perhaps most importantly, how should the informed consent form describe the risk of a pregnancy test or other reproductive health information being recorded in the study file, or the risks that the site might need to disclose this information to the state, and hence the risk of potential prosecution in some of the states post-Dobbs? And as for industry sponsors with participating sites in different states, they should similarly consider conducting an impact analysis of the changing laws on the ability of each of these sites and or the principal investigator to continue participation in such studies. They should also ask themselves how changes in the state law will impact site selection and recruitment of a diverse patient population. Will they be required to share pregnancy data, reproductive health information with the state? And what kind of indemnification will they offer the site? What kind of insurance coverage will they need? What kind of protection can they offer their participants?
Yeah, and Marylana, I want to hit on something that you mentioned, which is that state enforcement authorities might, be able to say researchers need to turn over their data, especially in states with abortion bans. So is there anything that stakeholders can do now to protect the researchers from having to turn over their data to law enforcement? For example, certificates of confidentiality. Is that a tool that might be helpful?
Yeah, that's a great question. These certificates are issued by the NIH and other agencies that are under the umbrella of HHS to persons who are engaged in sensitive biomedical, behavioral, clinical, and other types of research for purposes of protecting the privacy of research subjects. COCs allow the researcher and others who have access to research records to refuse disclosing identifiable information about research participants in civil, criminal, administrative, or other proceedings, whether federal, state, or local, by protecting the investigators and institutions from being compelled to disclose information that would identify research subjects. These certificates help to minimize risks to subjects by adding an added layer of protection for maintaining the confidentiality of private information. Now, COCs may be issued to cover any study that the issuing federal agency deems to be appropriate. So the research doesn't have to be federally funded. And so in the climate that we're in today, reproductive health information and abortion information can certainly be the type of information that a certificate would protect. But there are exceptions to the scope of protection offered by a certificate of confidentiality. Most notably, for purposes of our discussion, if the disclosure is required by state or local laws. So if a state legislature, for example, were to mandate the disclosure of these types of information, that may overrule the certificate and require the researcher or sponsor to disclose such information.
Got it. Thanks. That's really helpful, Marylana. So going back, we've been talking about the bucket of research where you're tracking pregnancy apps, tracking periods, taking pregnancy tests. What about this other bucket of research, Kate, that is using, embryonic stem cells or fetal tissue? How could that type of research be impacted by the Dobbs decision?
Thanks, Megan. That's a great question. And like everything we're discussing, it's really going to be a state law specific analysis, state by state. In some states, for example, Massachusetts, research using pre-implantation human embryos is permitted explicitly in the law. And that's notwithstanding the fact that Massachusetts has other certain requirements related to fetal research that are slightly more restrictive. But in Massachusetts, there was a clear decision made to ensure that work using human embryonic stem cells would be permitted and protected. Because embryonic stem cells are removed from embryos that have not yet been implanted, the impact from Dobbs will largely depend on how state laws define the terms fetus, what constitutes an illegal abortion by definition in that state, and whether a state recognizes some type of personhood at the time of embryo creation, or whether that only comes to exist after embryo implantation. At stake is really whether the necessary destruction of a pre-implantation embryo for embryonic stem cell research might trigger a state's illegal abortion law. This also has obvious impacts for IVF clinical procedures, as well as research aimed at improving IVF procedures. Recently, it's notable that Tennessee's Attorney General issued an opinion clarifying that disposing fertilized pre-implantation embryos, such as those that would be created in the course of in vitro fertilization treatments, would not, in fact, violate the state's Human Life Protection Act as a criminal abortion, even though the state includes pre-implantation embryos within its definition of what is an unborn child. However, it remains unclear whether disposal of pre-implantation embryos in the context of an IVF treatment, for example, is the same as actively destroying an embryo for purposes of HESC research. So I think these are all questions that are going to play out as these new state laws are interpreted and implemented. But we may certainly see jurisdictions where the conduct of human embryonic stem cell research is really no longer possible.
Thanks, Kate. I think a lot of what we've been talking about so far, the sort of clear stakeholders that you think of are how this impacts the sponsors and the sites of these studies. But what about the IRBs? Could the Dobbs decision have an impact on IRBs at all? They're responsible for reviewing the study details, the informed consent, as well as ongoing monitoring of the study. So should IRBs be considering adding a review of any Dobbs-related risks in connection with these types of trials that we're talking about?
Yes, definitely. I think, commercial IRBs and local institutional IRBs, particularly those that serve as a single IRB over multi-jurisdictional cooperative research should definitely consider whether the changes in state law are going to impact their screening process in connection with the review of study protocols, including the determination of whether the study is considered illegal in any state. They should also consider their review processes for protocols, informed consents more broadly, depending on the states in which any particular study is being conducted.
Yeah, I agree with that entirely, Marylana. And as I alluded to before, I think one of the hardest questions for IRBs right now is whether these legal risks that are presented by the implication of Dobbs are really ones that are appropriately considered by IRBs when they weigh the risks and benefits of a certain study to decide whether it should be approved. Are these legal risks really risks of the research that belong in the study's informed consent form, or are they legal risks that exist aside from the study by virtue of the state jurisdiction in which it's being performed? And that may depend in part on the nature of the study. If you have a study where the aim of the study is an abortion care intervention, one might say that the ramifications of participating in that is a more direct risk of participation than a study where the consequences of an unintended pregnancy may be more complicated legally because of the state laws in that jurisdiction. So I think these are areas and questions where IRBs are really going to have to self-reflect and create certain guidelines that they can rely upon to ensure that they are consistently applying these issues to their reviews.
Great. Thanks, Kate and Marylana. Listening to this discussion today and thinking through this topic, it's fair to say, I think that we've really scratched the surface here. We've covered so much good information, but there are so many other factors that go into development, performance, and funding of clinical research. There are a couple other areas that stakeholders should be thinking about. There's funding. I think we've touched on fetal tissue research considerations. There are so many other things to think about. To wrap up, I want to hear from you as to what is the biggest ticket item for stakeholders out of all of these considerations and all of these factors that go into a clinical trial. What should stakeholders really be focusing on as a priority when assessing whether and how Dobbs and related state developments impact their research activities?
I would say, Megan, right now, it's really inventory. Take stock of what research you're involved with, what research you're sponsoring, where is it happening, and what's the legal landscape there? Because you really need to get down into the details of what's being done in a study, what are the possible implications, and where are the jurisdictions that it's happening, and wrap your arms around the scope of that to get a good assessment of what your risks are and whether or not there's any changes you need to make in your research portfolio in order to protect your institution, protect your company, and protect the individuals who are participating in your research studies.
Great. Thank you so much, Marylana and Kate, for the discussion today. It's always so great to talk to both of you. And thank you to all of our listeners for tuning in. I'm your host, Megan Robertson. If you like what you've heard today, please don't forget to subscribe. Again, as I mentioned, Diagnosing Health Care is available wherever you get your podcasts. Thank you.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.